You sit down.
Very good. Good morning, my lady, my lords.
Yes.
My name is Mr. Davis. I represent the appellant, and by way of brief introductions as to who is in the court, my instructing solicitor, Mrs. Sutton, sits behind me. To my left, next to my client, the father, sits Miss Collins. Mr. Tadros represents the respondent mother, who is in court next to her solicitor, Miss Hollis. At the start, my lady and my lords, I seek a reporting restriction order, noting that, in fact, we are being live streamed today.
Yes.
I'm not sure if any other members of the public or press have attended, in fact. I know some more people have slipped in. I have an anonymised skeleton argument, if that would assist them, but we haven't been able to liaise with them if that is the case.
Don't worry about that. I mean, it's obviously no reporting can take place which might identify the children. But in the course of your submissions, as you have already, I think, started, can you call the parents, the father and the mother, and insofar as you, excuse me, need to refer to the children either by initials or by numbers, whichever you prefer, obviously not by name. Particularly if you're quoting passages, it's sometimes easy to use the name because the name appears in the passage you're quoting. So thank you.
I'm very grateful, my lord. I just wanted to check, perhaps slightly unusually, that you have the right core bundle, only because a number of versions of the core bundle have been submitted in this particular appeal.
In my room this morning at 9 o'clock.
Well, I'm incredibly sorry to hear that, my lady.
So
That was certainly, I think, not the appellant's intention or the intention of those instructing me.
I have not used the replacement one because it seemed to be identical, certainly in terms of page numbers, to the previous one. So I've just got the original with the addition of, I think, the respondent supplemental. I think that's the only new document that came in.
Yeah, so there should be. So there was originally a core bundle without supplemental skeletons. Then there was a core bundle with my supplemental skeleton. Then a core bundle with the respondent supplemental skeleton.
Okay. So the last document to come in was the respondent supplemental skeleton dated the 7th of February.
As I understand it,
which
yeah.
is pages 70 to 72. Right, then I think we've got everything. Thank you.
Very good. My apologies again. And there should also be a short authorities bundle. I'm totaling 139 pages.
Yes.
Very good. Sorry to run through that.
No, not at all.
Subject, of course, to what the court wishes to hear. I propose first to deal with a short opening, dealing with the background facts and, well, the relevant ones in any event, and how we've reached this point. And this is, of course, an appeal that focuses solely on costs, but engages a number of legal principles. Then to set out what I would describe as our core analysis of the case, where we see it going and what our main points are. And then, as a third limb, to go through the law, and here the law is contentious, dealing first with the regulatory interpretation point, particularly in relation to the what costs and merits regulations, and whether the legal aid certificate the mother has exempts her from section 26 of LASPO. And then after that, to deal with the grounds of appeal and on an either-or basis, because some of our grounds continue, whatever the decision on the regulatory interpretation point, to go through what the legal contentious points are.
The judge decided the issue of costs as a matter of principle.
Indeed.
Was that pursuant to direction he gave?
It was, yes, my lord.
In what order?
The order, I believe, was just after the fact-finding hearing. And is dated the 10th of September 2024. I quote the relevant parts of it at paragraph 15 of my skeleton argument.
Thank you.
It's not in contention at all, my lord, that that was the order that was made. What Recorder Samuels, King's Counsel, sitting as Deputy High Court Judge, sought to do was to obtain written submissions only on the principle of costs.
Yes.
And you'll see on the part I've quoted there, with the quantum to then be determined at a later date if a cost order in principle was made. So it was
Exactly. So it would be. I mean, I don't know quite what the conventional wording is nowadays, but it's an order for costs if an order was made, not to be enforced without leave of the court, because the court then has to determine financial resources and so on if Section 26 applies. The judge at the moment has not engaged at all with Section 26.
No, so the Section 26 point, which is now hotly contested before you today, was not canvassed before Recorder Samuels.
It might be hotly contested before us, but is it really before us? Are we not simply dealing with the judge's decision in principle, and either we decide that he was right or he was wrong, and we don't need to go any further than that?
That was, in fact, our original stance. What was to happen at the quantum stage, and indeed whether there was going to be any application to the Lord Chancellor, was not a matter for Recorder Samuels when he made this cost and principle decision, and not properly a matter for this appeal. Of course, the route we were taking, and I hope I set it out reasonably clearly in my skeleton, was that once you had the cost and principle decision, it was then a matter for the father to move to some level of assessment, and then a matter for him whether he was going to pursue costs against the Lord Chancellor. And the way I described in my written submissions, which are towards the end of the bundle before Recorder Samuels, is that in denying a principled decision, it was forever closed the door even to the chance of pursuing costs.
But your submission is that we do not have to deal with the application of the regulations for the purposes of this appeal.
That would have been my submission, my lord, save I think for your direction when you granted permission, which was that the regulatory points would be considered by the court and should be specifically canvassed in the skeleton arguments, which is why I think attention...
I understand that that was raised in the order granting permission to appeal, but what we moved on from that and what we're actually addressing is whether it really is properly before us.
I don't think I could submit it as properly before you in the usual sense of an appeal, my lord, because it's not something that was considered by Recorder Samuels and wasn't something that should necessarily have been considered by him when making the in-principle decision. It's something that would have arisen down the road.
Yes.
And indeed, completely at the...
Yeah.
I'm so sorry.
No, I just wanted to understand whether we're in agreement about this. You've identified, I think, that there might be 3 stages that your client would be facing in recovering any costs.
Indeed.
The first is the stages to, in principle, just regarding him and the mother in isolation from the rest of the world. Should there be any order for costs as between the two of them?
Yes.
Forgetting anything to do with regulations or statute. And in that first stage, as I understood it from the direction that the judge gave in September, the sort of result that you might have expected would be that the judge would say, no, there would be no order for costs, because I'm not satisfied that you've made out a case for having any order for costs. Alternatively, yes, you shall have an order for your costs of the fact-finding hearing. Or thirdly, you'll have an order for a proportion of your costs of the fact-finding hearing. Now, is that what you say was encompassed in the order of the 10th of September?
With a caveat, my lord, which is, whilst you're right that that is the first stage, we said that it was an important element of that stage that it was the father's open intention to seek only a de minimis cost award from the mother on assessment and to then pursue costs against the Lord Chancellor. Now, those questions were not before Recorder Samuels to determine when he made the in-principle decision, but we said it was something he should have taken into account. He could have given directions on that basis, made an order on that basis.
But at the moment, I'm not understanding what an application for a de minimis order for costs is, because as I understood it, you get an order for costs. You then see whether you can enforce it against the legally aided person through Section 26. And to the extent that you can't, because they have no resources, for example, you then seek to enforce it against the Lord Chancellor.
Indeed.
But the whole starting point surely has got to be that you're asking for a substantial order for costs, one way or the other, either in whole or in part.
So I think that's where we're parting ways slightly, my lord.
Right.
Because we say it's possible for the applying party to bind themselves to a position moving forwards in relation to what might happen at the assessment stage, where it might
Let's
go.
suppose you made an application for costs in this case on your client's behalf, and you said, I would like a token order for costs of £5.
Indeed.
That might be described as de minimis. Are you saying that armed with your £5 cost order, you could then go after the Lord Chancellor for £75,000 or £80,000?
That's exactly what we say on a proper reading of the law and the regulations, my lord. And that's exactly, in fact, what the father sought to do in this case. So we went before Recorder Samuels and we said we need a cost order in principle, but we openly bind ourselves to the reality that if Section 26 applies, and at that point there was no dispute about it, on a Section 26 assessment, which would incorporate an assessment of means, knowing the mother's means, there would be a very small, if not de minimis award.
Yeah, I understand that, but you're asking for a substantive order for costs, full stop. You're not saying an order for costs in the amount summarily assessed of £5. You're saying that at the Section 26 assessment stage, you're giving a binding commitment only to seek a nominal amount in the assessment stage.
Indeed.
You're asking for, I mean, you haven't yet made your submissions, but you're asking for a substantive order for costs.
A substantive order for costs,
Yes.
on the known basis that the father is binding.
I understand that.
Right,
So
so
the court-
let's suppose your submissions had succeeded before the judge. Could you just tell us what the costs order, what a costs order might have looked like that you obtained on that occasion?
We were openly going to seek £10, I think, as a reasonable Section 26 assessment sum, my lord.
So
And
an
we
order
said
for
that openly.
costs, but you surely you have to start with a substantive order for costs to begin with, and then you have.
Indeed, but the court would have known and did know that we were binding our position. It would have
Were
known.
you seeking 100% of your costs? Because the order for costs that you then go on against the Lord Chancellor must have in it either 10%, 50% of the. It's enforcing the order that has been made for costs. It's not some random other enforcement mechanism. So you can only. So the order for costs that you'll be seeking is for 100% of your costs?
Indeed, my lord. I'm not sure we're apart on that. So the order, the substantive order.
No.
I don't think we are.
All right. Well, I've caught up in that case, but in that case, your order for costs would have said that the mother shall pay the father's costs of the fact-finding hearing, and then you would have gone on to at some point record or concede that the amount that it's reasonable for her to pay is £10 or whatever.
Indeed. So the substantive order would have been order for the cost of the fact-finding hearing, and we
Right.
sought the entirety of the cost of the fact-finding hearing.
That's it. Okay.
I'm so sorry, my lord. It may be me that is being slow. Quite likely, in fact.
No. So you sought all of the cost of the fact-finding hearing, but you made quite clear that you were not asking that the mother herself should have to pay any amount beyond a nominal amount in order to act as a hook for your onward progress.
It was the open position. So the way the process would have worked on our close reading of Section 26 of the regulations is, from the court's perspective, there would have been an order for the cost of the whole of the fact-finding proceedings. Recorder Samuels would have then listed a separate hearing, the quantum stage. At that quantum stage, the court would have done two things. It would have assessed the costs payable to the father for the whole of the fact-finding proceedings as if Section 26 did not exist. And then after that, it would have conducted a Section 26 assessment. What should the mother pay? So out of that assessment process, we would have known what the full reasonable amount of the father's costs were, and separately what effectively contribution the mother was going to pay towards those. And we would have, and were in fact, clearly locking ourselves into saying the mother's contributory element would be £10. And after that, the third stage, as you've already identified, my lord, the father would have been able to choose, still a choice, to pursue the difference from the Lord Chancellor.
Right. So coming back to where we started, your case on appeal was that the only matter at issue was the first stage.
Indeed, but with the perhaps novel situation, we're not aware that this has tried to be argued before, that the father was openly saying,
No, I understand. I understand all that.
Session at stage 2B. as it
indeed,
were.
Yes.
Okay.
Yeah.
But so far as that, I mean, now we've sort of understood what the framework of this is as you submit. The framework still works if, for example, the judge has said, well, I think that the father should have a half, a quarter, or 3/4, or some fraction of the costs for this, that, or the other reason.
exactly.
So that would have been an outcome that the judge could have achieved at stage 1.
Absolutely. The court could have said at stage 1, the father will only recover 50% of the costs of the fact-finding proceedings, and then at the quantum stage might have heavily reduced the sum that is reasonable to be paid of that 50%.
But in the end, the father still had a case which meant that he had, let's suppose, it was, you say 50%, that he recovered £10 against the mother or whatever it was, and had the opportunity to pursue the balance with the Lord Chancellor.
Indeed, and that's the effect of Section 26 in the regulations.
Yeah.
And so you would have ended up with a difference. What's the mother paying?
No, I understand that.
Thank you.
And that's what
And
we lost.
the reason I was doing that is looking at what we need submissions on. And at the moment, I'm not convinced that we'd need submissions on, I think what you were saying was your third, the last area was the regulations.
Well, I will be guided by the court, my lord. I think the concern is twofold. I'll set aside part 1, which is it is the court that has raised it and engaged it. I believe, and I'll be corrected, that one of the points that is raised implicitly is that if the regulations just don't apply, if the Lord Chancellor was never an open gateway, then this is something that just shouldn't have been taken account of at stage 1, and our application for costs on the mother's case would have failed on general principles. What I say to you today, and I accept this is not canvassed in full in the skeleton arguments, because the way this point about whether the regulations apply has come about in my learned friend's skeleton argument, is that even if the regulatory point doesn't apply, or if you don't determine it, we still have good arguments in this case, re J and conduct, to say that there should have been a cost order in all the circumstances.
Well, yes.
I wonder, my lord asked whether the third stage is before us. I'm wondering whether the second stage is before us.
Oh, technically not, my lord.
Yes.
The only relevant point that arises out of those two stages is we say at the principal stage.
No, I understand that.
I'm so sorry to repeat myself.
It's right. Do you want to sit down for a second? I just want to check where Mr. Tadros is. Mr. Tadros,
My lord.
you've heard 3 stages. First of all, do you agree 3 stages?
My lord, yes, I think so. The difficulty with, I think, jettisoning the Section 26 cost protection considerations entirely is that the appellant's ground 5 criticises the judge for not applying in effect, a different test in circumstances where the open position of the applicant for costs is saying, this is my intention.
Yes.
And that ground 5, I think it is accepted, rises and falls with the appellant's case on Section 26 cost protection being applicable in this case.
Yes. Thank you. But apart from that, you agree?
My lord, I think
I'm not going to... Okay,
Forgive
thank you.
me.
Yes, no, it's all right. So you've heard what Mr. Tadros has said. I think I'd rather read. I don't know where I got it from. You weren't pursuing your ground 5. Was that a misunderstanding on my part?
We're not pursuing ground 6, my lord.
And ground 6. Okay.
Ground 6 was what I best describe as the ambitious ground.
Yes.
So ground 6 is struck, and I've informed my learned friend this morning that we're not going to pursue costs of the appeal described at the end of my Skelly as pro bono costs of the appeal. So those 2 issues are not going to come before.
Yes. Okay.
But grounds 1 to 5 are very much live. Grounds 1 to 4 exist whether the regulatory point stands or not, or whether you determine it or not. I do accept that if you determine the regulatory point, and I hear that the court may not wish to, if you do not determine the regulatory point, I can run ground 5. If you determine the regulatory point and determine it against me, then ground 5 must fall.
I can tell you we're not going to determine the regulatory point. It wasn't argued in front of the judge. I don't think, I appreciate it was flagged as a potential point in the permission order, but it just wouldn't be right for us to deal with it. So no, we're not going to. So can you tailor your submissions with that in mind? Yes.
Well, I'm very grateful, my lord. In fact, that may shorten them dramatically because there was going to be some time on
Right.
the interplay between the regulatory provisions that have been placed before you in the authorities bundle. I'll deal first, my lady, my lords, unless you object, with an opening that canvasses what I say are the relevant facts in relation to costs. The factual summary, I appreciate you don't have all of the documents from the proceedings below before you. That is intentional. We did not think they were relevant and much of it is agreed. The factual summary in my skeleton argument in relation to the allegations that were advanced is agreed and not contested. These were what can best be described as very lengthy proceedings, whilst you are dealing with the question of costs arising from the fact-finding hearing. How we got there is incredibly relevant. The parties were married for around a decade. There are 4 children at the heart of the case. I'm not going to deal with any of the children in detail. It's not particularly relevant to this application. We know...
Do we need the facts?
Yes, go on. Sorry.
We know that the relationship between the parents saw domestic abuse perpetrated by the father against the mother. In his fact-finding judgment, Recorder Samuels determined that and made those findings. And we do not shy away from that. If you look to page 94 of the core bundle, there is a helpful summary of the overall findings by the judge. And he found that the father was aggressive and threatening towards the mother in the course of their relationship and after it ended. The behaviour included threats.
Sorry, hold on.
I'm so sorry, my lord.
No, because it's not 94. Is this in his cost judgment?
No, the fact-finding judgment, paragraph 7.
Right, that page 97.
I see, I'm going to be 3 pages out. 97, I'm very grateful, my lord.
Yes.
At paragraph 7, findings for these purposes that made against the father, that he was aggressive and threatening
I don't
towards...
think you need to read them out. We've read them. So the 6 sub-paragraphs.
Indeed, well, the first 3 are the findings made against the father in relation to the domestic abuse in the relationship. And there's some suggestion by my learned friend that we're seeking to equivocate or set off or minimise those findings, that we're not. We accept them, they're there. We also know, and this is going to be at core bundle page 129 of the judgment, I suspect, in your version. I'll try not to quote extensively unless I need to, my lady, my lords. But paragraph 89, but the second half of it over the page, which I think is at your 129.
Yes.
We know that at the start of the separation, the children were saying they loved their father, and that there didn't seem to be any particular issue. What we also know is that the children's relationship with their father ended after the parties separated, and at the time of the fact-finding hearing, he had not seen them for over 2.5 years, recorded by Recorder Samuels. The reason how and why we reached that point are the allegations made by the mother that are not those domestic abuse allegations I've already taken you to and summarised, and which we describe in my skeleton as the tranche B allegations. The reasons why there was such a delay relate entirely to what I call the sexual abuse allegations, which dominated the case. Now, my summary is agreed. I won't read out the allegations unless it will assist the court. The summary at paragraph 5 of my skeleton argument as to what those allegations entail is not disputed. The C100 was issued in May 2022, but it took until the 14th of July 2023 for the court to properly come to grips with the case. No criticism of the court. Everyone knows the enormous burden they face. There were 2 for Hedgers before that. We also know, because Recorder Samuels has observed the same in his fact-finding judgment, that the nature of those allegations evolved across 8 statements rapidly. 108 or 109, I think, of your bundles, my lady, my lord, whereat, paragraph 41, the judge passes comment on how that case evolved. Really, though, so far as one needs to consider the impact on the proceedings or the view of the court, we need look little further than the comments of the designated family judge. This case came before it was allocated to the High Court, and that's at page 97, I suspect, of your bundle, paragraph 9 of the fact-finding judgment, that the allegations were of the utmost seriousness and complexity. And that was a comment directed entirely at what I call the tranche A allegations, and the obvious one that is outlined in that paragraph, which was at the heart of those allegations. The father made a cross allegation as the proceedings evolved of alienating behaviours, as the contact with the children showed no sign of progression, but also as the children moved, and you would have seen this in the fact-finding judgment, from a position of loving their father through to a position of entirely rejecting him, and indeed expressing hate towards him, and for at least 2 of the children, a wish to harm him. Recorder Samuels notes, at my page 159 and your page 162, that the mother pressed her case relentlessly in relation to the allegations. Now, I pause there because it is a finding of Recorder Samuels that the mother did none of this intentionally. This was not a conspiracy that she had intentionally put together to launch against the father, but nonetheless, she behaved in a certain way and did, and this is an important paragraph, at paragraph 184 of the fact-finding judgment, alongside pressing relentlessly for other professionals to accept her perspective and act when they did not act, cite Tracy for me, my lord and lady, when they did not act or act in the way she wanted, she would redouble her efforts. She pressured the children to start talking. She is convinced that he is a bad person who poses a danger to her and them. The case, because of the tranche A allegations, was allocated to High Court level. I will not go through the full chronology, but very swiftly after July 2023 to High Court level, and Recorder Samuels then took control and became the judge that has heard it ever since. There was an initial attempt at a fact-finding before Recorder Samuels in January 2023. That was abortive, we say, because of evidence that was entirely associated with the tranche A allegations coming in late, the abortion of that fact-finding hearing. And I note that now because that fact-finding hearing became an important part of the cost judgment we're about to turn to.
Could you just go back to what you were talking about in relation to intention? I noted you to say that the judge found that the mother's behaviour had not been intentional.
Indeed.
Where does that finding come from?
So the overall conclusion at page 162, I'm so sorry to have the numbers askew, my lord, but 188 deals with the overall finding of alienation or alienating behaviours. As to intention,
184.
I'm very good. 184.
Sorry, I'm at a different part of the judgment because the judge sets out his findings at 2 points, the beginning and the end. Is it paragraph or page 184?
Paragraph 184.
Thank you.
And the point that comes out of 184 is the mother convinced herself that the allegations are true.
Yes, but that says nothing about intention. Indeed, if you look at the findings, try to find where they're 188
Yes.
it says something different.
Well, it does, yes. That speaks to, so we distinguish because of the approach of the judge, or certainly our understanding of the approach of the judge, and he revisited this point of intention in his cost judgment, which I'll turn to in a moment. We'd
Yes,
understood
but
that.
I just want to understand whether, because it might be important, whether you were saying that the judge had found that the mother's behaviour was unintentional, because I had not found in the judgment any statement of that kind.
No.
One's left to make what one can of 184 and 188, essentially.
That is exactly the case, my lord, yes.
Well, one might say that 184 suggests that it was intentional. Leaving aside the grief, she has pressed relentlessly other professionals to accept her perspective. When they haven't acted in the way she wants, she's redoubled her efforts, etc., etc., etc. So that is intentional, isn't it?
I hear the strength of what you say, my lady. I won't push the point on intention. It was our understanding of what Recorder Samuels had wanted to say in his judgment, certainly in our discussions with him since and in the cost judgment, but you are correct that there was no finding that there was an unintentional set of behaviours. One is left to make what they can of 184. It's important, or we say it's important to note, certainly it's important for the father, that the mother was legally aided throughout these proceedings. She deployed state resources to advance this case. And I've noted in my skeleton argument at paragraph 11 and made the submission to Recorder Samuels that it's also important in the light of that to note that she advanced that case without any obvious limitation or restriction, or any obvious, to us at least, attempt to narrow the issues. And you've already had me take you to the part of Recorder Samuels' judgment where he talked about the 8 statements and the ever-growing case. It is a feature of this case that at the eventual fact-finding hearing that was effective, there were an array of serious allegations that were not pursued, but which were never formally withdrawn. The effect...
Speaking for myself, I'm not sure the relevance of using state funds, because the cost order will take us to the authorities in due course. The principles are reasonably well established. You look at the litigation, you don't look at how people are funded or not funded for the purposes of that litigation.
So it's material in this case, my lord, because of the impact that that has had on the father. And what all the authorities tie back to, if you were to draw a general...
It's the actions, it's not the funding of those actions.
No, I agree with that. For the purposes of making a cost order, I entirely agree.
Okay, thank you.
The effect of this, particularly when we come to look at the authorities, is notable, and the central strand that comes out of the authorities, of course, when considering costs, is the interests of children. One of the overarching principles is a cost order may cause aggravation in the relationship, may limit resources available to the children, may be counter to the children's interests. Well, the first and obvious effect of the mother's allegations, the tranche A issues, were that they expended a significant amount of court resources, we say unnecessarily. This case was allocated to a High Court level. A number of attempts were made to list a lengthy fact-finding hearing. One was ineffective due to a lack of judicial resources. One was then ineffective due to the failure of third parties to provide essential and voluminous evidence in relation to the tranche A points in time. And then eventually, the third one was effective in summer of last year, or early summer of last year. Significant impact, though, on court resources. And when we compare and contrast the tranche A allegations against the tranche B allegations, our focus actually, we talk about the grave nature, the lurid nature of the allegations, and that is important, but the focus is on the procedural impact. It's the procedural impact of these allegations that has increased the costs incurred by the father dramatically in this case. It is the procedural impact that has lengthened the proceedings and caused delay in the progression of this case. It is the procedural impact that has led to a lot of the harm that now faces this father and indeed these children. The children separately have also suffered significant harm when we turn in our minds to what are the interests of the children in this case. Recorder Samuel's judgment clearly shows the harm and damage done to them. They've moved from loving and wanting to see their father through to having a false, factual, narrative understanding of their childhoods. We do not yet know how much work that is going to take to reverse, if it is even possible to reverse. We know they now entirely reject the father, and it is not clear what progress can be made in relation to that. Certainly wasn't clear when Recorder Samuel's King's Counsel considered the costs application. And separately, we know that they are suffering significantly. If you turn to paragraph 75 of the fact-finding judgment, I won't name the child. I would ask you to read that paragraph, though, my lady, my lords. That speaks to the consequences for the children of the mother advancing this case. I'll pause quickly whilst you, I know it's a lengthy extract.
Yes.
That is and the reason, one of the reasons Recorder Samuel took time to quote that is that's in the context of a mother who gave evidence that since the children had started making the allegations, their psychological presentation had improved, and Recorder Samuel's found against that assertion in the mother's evidence. And you can see, if you look to paragraph 74, I don't want to revisit the point about intention, but exactly how this all evolved. The mother, post-separation, was liaising with the local authority, and this starts, paragraph 74 follows from 73, which is in relation to a February 22 local authority assessment. This is the month after separation. And then this 74 looks back on it, in Recorder Samuel's words, notes that she was raising allegations of domestic abuse, but not the tranche A allegations. She wanted the local authority to stop the children's contact with the father. They refused. She continued her allegations, and she was then told in April 2022 that if the children disclosed to professionals details relating to sexual abuse within the home, that might be something that would stop contact. That is then the core genesis, perhaps fateful advice from the local authority. And you will note at the top of the following page that it was a few weeks later, in April 2022, that the allegations first emerged. The point that arises out of all of that, my lady, my lords, is it is the pursuit of these allegations relentlessly over a number of years that has directly harmed the children. If the mother had not been pursuing these allegations without any limit, apparently unbound, if she hadn't been relentlessly trying to prove them through whatever way possible, if she hadn't been feeling it necessary to force the children to talk, my Tracy, to try and prove them, it may well be that significant harm to the children would not have been done. This is a case where the harm springs directly from the proceedings.
Yeah, I'm not. I understand why you make the point, but it's not the basis for an order for costs. The basis for the order for costs is not the consequences of reprehensible behaviour, it's the behaviour itself leading to the infliction of the costs. The sequence of events was that 22nd of April, there was said to be an allegation by the children to professionals. In early May, from recollection, the mother obtained an injunction That's the gateway, is it, to public funding?
It is, yes. I should say, I don't want to mislead the court. We presume that's what the gateway was. I've never had that confirmed.
Right. And then a few weeks later, in the same month, the father issued his application.
Indeed, yes. I accept that there is a difference between the litigation conduct itself and the effect for the purposes of reprehensibility.
Yes, I mean, just that, you know, those may be welfare submissions that you're making or going to make, but in terms of just the costs issue, surely the only important point is that it was very serious. I mean, the proceedings were very serious, and the course that they've taken has had very serious consequences.
I think you encapsulate it perfectly, my lord, within very serious. The reason it's very serious in large part is because of what's going on around it, but I accept that point. And then finally, the effect on the father has also been significant, and I've outlined that at paragraphs 12 to 14 of my skeleton argument, and that in large part is why we are here today. He faces potentially being driven out of these proceedings by the costs that he has been required to incur. He faces potential homelessness. He has suffered significant mental health problems as a result of this entire situation. I just pause there because the impact on the father is again something that will be tied back to my analysis of the law. A lot of cost neutrality law, the principles behind it, is again tied to ultimately welfare of the children, fair progress of the proceedings. What might be happening in this case as a result of the father's legal funding and how the case has evolved is important. It doesn't necessarily go directly to the question of costs, but it's not something that can be disregarded, and it certainly impacts which tests are applicable. It was suggested, I don't think this is pursued by my learned friend today, I do not know, but before Recorder Samuels, it was suggested that it was the father's choice to obtain private legal funding when he discovered he was not eligible for legal aid. I say, so far as it needs to be said, that that is not a good point. This is a case that quite obviously required the assistance of lawyers, and the court would never, I say, encourage a litigant to appear against this sort of factual background in person. On the then second stage of my submissions, and a far shorter one, my lady and my lords, the core analysis. Well, the heart of it I think you already have. The tranche allegations warped the proceedings. They stand apart in a class of their own. They are the cause of significant procedural impact, delay, and more importantly, costs. And whilst I've heard my lords' points on this, they have had an overflow effect, not just onto court resources, but onto the children directly and onto the father. This is not about compensation. Any suggestion that it is wrong. The father does not seek compensation. He can never be compensated for what he has gone through. He simply seeks a costs award, in large part so he can continue funding his representation as the proceedings continue to move forwards, because they are not yet over. We're then left, because I'm cutting out my points on regulatory interpretation, my lady and my lords, with what was the right approach for Recorder Samuels to take. Well, first of all, and this is what the initial grounds deal with, Recorder Samuels should have dealt only with the question of the principle of costs, and that's already been very helpfully surmised by the bench today. Should there have been a cost order at all? Should it have been limited to a percentage? Recorder Samuels, though, drew in other factors, which we say properly went to quantum. And I've dealt with some of those in my skeleton argument.
By using the word quantum, do you mean different from percentage?
No, so quantum can include percentage.
Yeah, but so, I mean, in the end, isn't the argument that the judge didn't focus on the fact that it wasn't all or nothing. That if he thought a factor was relevant, he should consider whether it was relevant to either reduce or to eliminate a costs liability. That when you're accepting that, if you accept that he could have ordered a percentage of costs, well then issues of contribution or balancing against other parts of the case that were found, proved, those were all within his remit, were they not?
To tie it to a percentage, yes,
Yes.
Absolutely, my
Yes,
lord.
so that's not your point. So could you just explain what your point is? Is it the one that I've just made to you, namely that he could have used those if he thought it appropriate to reduce the amount that was going to be in principle
Yes,
required of the mother, but it didn't equate to him treating those things as being there and having to extinguish the amount that should be payable.
yes, and so in large part that is the heart of our submission, my lord. You will see that Recorder Samuels's cost judgment should be just before the fact-finding judgment. In his conclusion, and he dealt with the public funding point and generally just having sympathy with the father. His conclusion was effectively that this was not a clear-cut case in the way that some of the authorities, or the previous authorities, seem to have been. Just generally, this is in relation to the Re J point, which starts at paragraph 45 of the cost judgment. Re J was not a clear-cut case in any event. About 2/3 of the allegations were proven, a third of them fell away, and Lord Justice Wilson in that case ordered a 2/3 percentage. But one of the issues we take is that the learned judge appears to have said, because it's not a clear-cut case, because it's effectively messy, there are findings both ways, criticisms both ways, it's not suitable for a cost order. That's my précis of the judgment that runs from 45 and then for the next few pages. That is the wrong approach for the reasons you've already outlined, my lord. One, it is not about simply setting off one allegation against the other. Two, in this case, even if that was the approach, it would be a wrongful approach because the tranche A allegations were so much more material to how things evolved. And the findings against the father, whilst serious, from a cost and procedural perspective, were of a much lesser order. That's the tranche B points. As I say, that's not to diminish them as domestic abuse, but to diminish them so far as their impact on the proceedings and on costs went. The court could have ascribed a percentage and should have done if its view was that it's a messy case. To simply skirt the issue is wrong. It goes slightly further though, because Recorder Samuels also then dealt with specific points and appeared and specific points and focused in on the adjournment of the first fact-finding hearing listed before him in January 2024 and the second fact-finding listed overall, the first one having been aborted due to an error in the administration of the courts. And that's at paragraph 61, and that crystallises some of the points I've already started to set out. The reasons in 61.1 that he gave to adjourn the hearing were not reasons that related in any way to the mother's litigation conduct. One, a percentage approach could have been taken. Two, that is wrong as a matter of interpretation because the existence of the fact-finding hearing as it was entirely related to the tranche A points, and the adjournment of the fact-finding hearing was entirely related to the tranche A points. Whilst within the bubble of the hearing itself, yes, there were lots of reasons why it was adjourned, counsel trying to absorb huge volumes of late received ABE videos, lots of written documentation coming in late, the need for further information. One should step back and say, well, why is this happening within the scope of the litigation? And that's what Recorder Samuels failed to do. So he shouldn't have honed in on a specific adjournment in any event. And if he did do so, he should have appreciated that the loss of that hearing and the lost costs was tied to the tranche A points and to the mother's case. And then little 2, a summarising point from the previous pages, the judge makes the case that this is not a straightforward set of proceedings where allegations are made by one party found to be proved against the other. And that the father lost on some of his points, and we accept that openly. But again, not a reason to avoid or skirt a costs award. If a clean sheet approach applied, the court is well placed to assess the overall winner. Now, I say in my skeleton argument that the use of the word winner in family proceedings is deeply uncomfortable, and that must be right. But for the purposes of costs proceedings and a cost application, the overall successful party is decisive as authority. I've set out in my skeleton argument on that point. And in this case, given the scale and impact of the tranche A allegations, the fact that the father obtained a dismissal of those allegations against him and a finding of the alienating behaviour point meant that whatever else was happening in the mess of the background of the proceedings, he was the overall successful party for the purposes of costs only at the fact-finding hearing, and that is what is missed again from Recorder Samuel's analysis. He simply surmises that because it's messy, because there are findings both ways and criticism both ways, it's not appropriate for there to be a cost order. He should have engaged in a much more robust analysis. I know that my learned friend will say, and will turn to, a lot of these criticisms against the father and his behaviour, and in and of themselves, as you list them out, some of them are unpleasant. Some of them very unpalatable, particularly in relation to the domestic abuse issues. But one again must step back and look at the overall arch of the proceedings. And when you weigh again the tranche A allegations, when you take them into account, it is clear that the tranche B points, effectively for the purposes of costs, are of limited importance. At 4, I only draw your attention to it because of the discussion we had earlier, my lord, my lady, about intention. And that's where Recorder Samuels revisits this question, although I would accept in the way my lady describes it that it's not clear exactly where we land on intention. But he says that the mother is right to point out my finding in relation to the allegations of sexual abuse in relation to the children was not that the mother had maintained allegations which she knew to be wholly false. It is, as I set out at paragraph 184 of my judgment, that she had convinced herself that he did these things. Again, that is not a particularly relevant factor, and it's certainly not a factor that should extinguish costs entirely in the circumstances of this case. It ignores the procedural impact of advancing those allegations and the wider impact of advancing those allegations only to lose them. And then at 62, which is worth reading, my lords and my lady, before you come to your final decision, Recorder Samuels effectively brings everything together, but focuses again on the mixed picture, which for the reasons I've already outlined to you is simply the wrong approach in the circumstances of this case. It was not an equally mixed picture. A cost order could and should have been made. Now, in my skeleton argument, I touched upon these points at paragraphs 44 and 45, and hopefully have just about expanded on them enough, my lord. That then leaves us with the appropriate gateway to costs. I say there are...
Sorry, before you get to 44 and 45, at 41 in your skeleton, you've listed a number of points. And you've taken us through the judgment, in particular paragraph 61 and 62. I rather understood your submission to be, in respect to the points listed in 41, that those were relevant points that or factors that the judge seemed not to take into account. Was that your submission, or have I misunderstood it?
No, it is, my lord, but
Are you coming to that later?
Indeed, my lord.
Sorry, I'm
No,
jumping
no, no, no.
ahead.
It's a very good question.
Sorry, I thought, because you've taken us 44 to 45, I assume. Don't worry, I've interrupted you.
No, so paragraph 41.
Don't worry, go the order you were planning to go, please.
I'm good. So we identify 2 established gateways, and then we propose a third new one at ground 5. The 2 established gateways we say are Re J, is this a standalone fact-finding hearing within private law proceedings? The second gateway is...
So we're onto the law here, are we?
Yes, we are.
Right, okay. Why, I mean, before you pick up speed on this, I mean, we've obviously looked at Re J, and we looked at what was said about Re J and Re T. I mean, do you need more than one gateway on the basis of your main submission, which is that you will make the same submission you made to the judge, which was that there was more than enough here to illustrate reprehensible litigation conduct to act as a stepping stone to making some sort of order for cost.
Indeed, that is our
Yes,
point 1, effectively, my lord.
I mean, is that your starting point before we start getting into a more detailed analysis?
So yes, that is our starting point. That was our starting point. So we canvassed both points before Recorder Samuels, and you'll have seen that, I suspect, in the written submissions. But the core thrust is this is just unreasonable litigation conduct, and that gateway is wide open in the circumstances of this case.
Yes, but I mean, if we go on to Re J, we'll probably have to say something about this. But it gains no support at all from Re T, does it?
In the context,
the idea that there are special rules for fact-finding here, it stands to reason that a fact-finding hearing is maybe a little easier for a court to think about costs in, because it's got its findings and its non-findings and so forth, and so it is an area in which the court can make an order for costs, and it might be fairly easy for the court to see whether this was really in the realm of costs orders or mostly not. But are you going to be submitting that different principles apply?
that is our case,
Yes.
my lord,
Right,
yes.
well, you're speaking for myself, you're going to have to make that good, because I can't see any need for it at all. It's obviously a subspecies of situation in which cost applications might be made, and you were making one in this case. But you're going to be submitting to us, as I understand it, that the well-established principle that you don't make orders for costs in children cases without reprehensible conduct does not apply to fact-finding.
To certain types of fact-finding, yes. So Re J was very careful, Lord Justice Wilson, to say this is not every single case. But yes, to certain types, unusual types of fact-findings where allegations are particularly warping or serious or dominate a bespoke exercise, we say, in line with Re J.
Yes. So what should the test be in what we call Re J cases then?
A clean sheet.
And
Which is
just who won?
Well, a clean sheet isn't just who won. Who won is often the decisive factor.
Yes, so what is the reason going to be for making an order for costs in a fact-finding case then? What is a typical reason that wouldn't engage reprehensible behaviour?
Well, in the circumstances of bespoke hearing dominated by allegations like this, we would say the clean sheet would be led by who won. And I've said that, I hope clearly, my lord, that this is not a case where there are other factors to weigh in the balance. You ask clean sheeters, is it just who's won? And that's not entirely correct. There can be other factors, but who won is often the decisive factor. In fact, it should be the decisive factor unless there are things that weigh heavily against it, like conduct.
Right. So I've understood now, thank you. So special rules for fact-finding.
Indeed. But perhaps I'll deal with that first, my lord, and then swing.
Is that your ground 5?
No, I
I'm
think
trying to tie it to
ground 4. I think.
ground 4, sorry.
Yes, well, 3 and 4 effectively
3 and
engaged,
4,
but I
thank
think it's properly ground 4. So this court dealt with Re J 15 or 16 years ago. broad point made out of it is the one we've already canvassed, my lord. I don't propose to take you through the relevant parts of VJ unless it would assist you. In summary, that where there is a bespoke fact-finding exercise predicated upon allegations which are serious, the usual cost rule, general principle, cost neutrality, as I described it in my skeleton argument, does not apply, and a clean sheet approach applies. Save that, there is a clear distinction by Lord Justice Wilson in that case, to say that this should not be for all cases, unusual cases. It doesn't necessarily define that. And it's clear that a compartmentalised approach can be taken if the exercise warrants it. And really, my reading of it is it just ties back to, are there serious allegations that are contested? A clear winner, effectively. Now, my learned friend raises RET and RES, and you have raised RET on this point, my lord. Both deal with public law proceedings. Both are distinguishable in their own ways. I'm going to deal with them quickly. So in RET,
Sorry, are they distinguishable because they're public law cases? Is that one distinction?
well, that's not the main distinction, because just because something's
Well, is it a distinction at all in your submission?
no, it's not a. The fact just generally that a case is a public law case is not a distinguishing factor, but because they're public law cases, what they deal with is distinguishable. So, for example, in RET, the court was directly wrestling with a single issue of principle, authorities bundle page 35, which is whether in care proceedings, at 29, a local authority should be liable to pay an intervener's reasonable costs in relation to allegations of fact reasonably made by the authority against the intervener, which have been held by the court to be unfounded.
Right, so what's the distinction that you're drawing?
Two, one, the law then and the analysis focuses on that question, the liability of a local authority within public law proceedings to pay costs following a fact-finding exercise, does not deal with private proceedings between two parents, and that is, I say, a material distinction, especially when one looks at the principles that underline that difference. So in public law proceedings, there are differences in principle. For example, it is presumed per res, and I flag this in my skeleton argument, that all parties are there to assist the court in public law proceedings, and allegations which are made by a neutral local authority with no interest in advancing them have to simply be met through a quasi-inquisitorial process, my summary. That cannot be the case in private law proceedings, but, and there is no authority before you on this, my lord, but I've made the point in my skeleton argument, but where warring parents often advance positions that are not directly linked to the interests of their children, and where they seek to advance litigation in ways that is unhelpful. So that analysis, when you look at the general principles springing out of RET, is only applicable, we say, to public law proceedings. And in fact, what RET says is that there may be other exemptions in private proceedings, and that's a point made by RES as well. So,
could you just go to the passage in RET which makes that one?
So RES may be the more helpful one, my lord, at Authorities Bundle page 22, because this is reflecting upon RET. At paragraph 30. Here the Supreme Court analysed RET in slightly different circumstances on appeal costs. And what the Supreme Court says is, a few words in paragraph 30, are there circumstances other than reprehensible behaviour towards the child or unreasonable conduct of the proceedings which might justify a cost order in care proceedings? It is clear from the authorities cited above that there may be other such circumstances in private law proceedings between parents or family members should care proceedings be any different. The important point that springs out there is the Supreme Court is demarcating public law proceedings.
What's the answer? What answer is given?
But there is no answer. There is just a single general suggestion. I'm in no way being denigrating the dicta or judgments of previous judges. But there is a general suggestion that there are other gateways. They're never identified in a comprehensive locked list, and the usual one is reprehensible conduct or unreasonable behaviour.
All that Baroness Hale is saying there is that looking at what Lord Phillips said in Reed T, it can't be read as ruling out the possibility that there might be circumstances in which an award of costs in care proceedings might be appropriate and just, but it doesn't actually tell us what those circumstances are, or indeed what Reed T stands for. I think in order to look at that, you need to look at Reed T.
Well, I agree, my lady.
And she also says in 32 that there's no reason why necessarily local authorities are in any worse position than private parties than 33. They shouldn't be in any better position than private parties.
Well, indeed, my lord.
And if we look at Re T, in paragraph 31, Lord Phillips points out that what Lord Justice Wilson said, it is at odds. So I must admit, I read Reed T as disapproving Re J.
Yes.
Well, I think a number of judges have, my lord, including...
Well, with the moment.
What we say is, what Reed T does not do anywhere is say categorically in private law proceedings, Reed J is not applicable. All of its analysis in relation to Reed J is in relation to the circumstances that came forward in that case. And that is in fact a point made by now Mr. Justice.
Do you mind, before we go to that, could we just go back to Re-S and a paragraph we didn't look at, which is 26. This is Baroness Hale's last paragraph under a heading of a sequence of paragraphs to do with costs in children's cases, which begins at paragraph 15. And so that again at paragraph 24, at least, sorry, 26 at least to me, strongly suggested that the Supreme Court considered that there wasn't any difference between private and public law cases. Of course, there may be a difference in the application of the test, because it might be very hard to find that a local authority had behaved reprehensibly if it was purporting to carry out its statutory responsibilities. But we know from G&E that there is the odd case where they have done so and have been ordered to pay costs.
Well, I'm aware of that, my lord, but it's perhaps a slightly different, more nuanced point. Even when you look at 26 in Re-S, it's not again categoric. All the reasons which make it inappropriate as a general rule, that is not categoric. To make cost orders in children's cases apply with equal force in care proceedings between parents and local authorities, as they do in private law proceedings between parents or other family members. I pause there because our submission is, what Baroness Hale does is take private law principles and add them to care principles in relation to costs. What is not said is it can go the other way around. You can't take care cost principles, the objectives the court's focusing on when considering costs and care principles, and apply them back into private law proceedings. They're different against, because some of those principles focus on the role of the local authority and the general view that all parties must be assisting the court. And then she continues, they lead to the conclusion that cost orders should only be made in unusual circumstances. Two of them were identified by Mr. Justice Wilson, as he then was, and that goes to exactly what we've been discussing. But again, that's not categoric. It's not said, here's the list of unusual circumstances. It's not said, these are the only two circumstances.
Last line as well. She's not saying in terms what we're putting to you, but there it is.
But again, my lord, if you then turn to paragraph 44 of VT.
Well, paragraphs 43 and 44 in the Court of Appeal again seem to suggest that the exceptions depend upon the manner in which one of the parties has behaved. In 43, local authority won't have costs awarded against it where no criticism can be made of the manner in which they perform duties.
But again, my lady, I agree with that. But
It's all part and parcel of a general principle, and all right, you can say the categories are not closed, but there's nothing really apart from the dicta in Read J that suggests that you have a carve out for fact-finding hearings. And indeed, Read T says you shouldn't have a carve out.
In particular, and we've looked at one paragraph, 44 says the same,
yeah.
that we've concluded the general practice of not awarding costs against a party, including a local authority, so it applies both to public law proceedings and private law, and then not subject to an exception in the case of split hearings,
well, indeed, my lord, but
i.e. fact-finding hearings.
But split hearings is a public law term of art, so public law proceedings.
But you had a split hearing in this case.
Indeed, but within private law proceedings,
Yes.
they are never described as split hearings. Within public law proceedings, they are described as split hearings. I accept it's the same overall procedure. And again, what is being said here is there is a general rule and there is no categorical list of what can circumvent it. And in fact, in part, Read J is upheld, but I accept that in the case of split hearings, perhaps if I say it like this, my lord, we accept that Read T disapplies Read J in relation to fact-finding hearings in public law proceedings.
And then you've got Re-S, which suggests that there should be no distinction drawn between public and private law proceedings. So where does that get you?
Well, although Re-S is not clear on that, because as I've already said, my lady.
Okay, so your submission is that there should be, as you submitted a moment ago, clean sheet in respect of fact-finding hearings in private law proceedings.
Indeed. And on the Re-S point, Re-S is clear in terms that there may be other exceptions
Yes.
in private law proceedings. Re-S demarcates them.
I understand that. Is there any first instance authority that you want to refer us to in which the clean sheet approach has been applied to fact-finding hearings in private law proceedings?
No first instance proceedings that I place in the authorities bundle, my lord, because we're dealing just with the principle, and one of the submissions that we had is that actually there's a reasonably confused approach at the moment of first instance to this point. A number of judges, I haven't canvassed a smorgasbord of judgments to take an average, but a number of judges say that Read J does not apply in private law fact-finding hearings. I believe, in fact, my lord, you have made that decision.
Is that in our bundle?
Your decision.
Well, yes. I mean, because if I've said it, I can't remember. But where's that come up?
I think it's the case of M&F, legal paternity, it starts at page 46 of the authorities bundle. Paragraph 46, my lord.
I thought that's saying what I was saying a moment ago.
It is, my lord. So well, at
Oh,
first,
see, I'm sorry. I'd understood that I'd said something different on another occasion.
So a number of first instance decisions saying that Read J doesn't apply to fact-finding hearings. In other words, not following Read J.
not following J, and then others that do. The one that we flagged in my skeleton argument, or my supplemental skeleton argument, in fact, on this point, is the case before the Court of DS, King's Counsel, now Mr. Justice DS. Of course, does not bind you, my lord, my ladies. M&F, application for costs following fact-finding hearing.
Sorry, what page is that?
So I'm referring to page 2 of my skeleton argument to flag a judgment which is not set out in detail, but where Mr. Justice Diaz, who then again was as a recorder, and this is an agreed decision, so it's not in the authorities bundle. There's no dispute that Recorder Diaz came to this conclusion.
Well, it might be interesting to see why.
He concluded.
What page are you reading from?
I'm just reading from my supplementary skeleton argument, my lord, which is at page. The relevant part is at page 65, I suspect, of your bundle. You're looking for a page that ends with paragraph 4, references to the first 2 skeleton arguments, and then the top part of that.
Yes.
And it's agreed that Recorder DS, King's Counsel, said this when considering Re J and Re T, and his judgment was that he judges the decision in Re T to be fundamentally about public law proceedings and costs, distinguishable from private law proceedings, and he was not bound by the decision. So, the heart of the point, at first instance, judges are taking different approaches to this
Okay,
point.
but that's the only one on the other side that you found.
Indeed, my lord, I think you have 2 on one side for my learned friend and 1 on the other side for me, and those are the 3 we found between us.
Okay.
That cut directly to this specific point.
Help me. I thought your submission, is this a sort of bolt-on submission? Because I thought your submission is that your submission is the mother's behaviour, conduct of the litigation has been reprehensible and unreasonable.
That's the heart of it. And I'm so sorry, I've said I would deal with Re J first, but I may not have been clear, my lord.
Yes.
So the Re J point is the second point, but it was also a point before Recorder Samuels. He chose not to go through the Re J gateway or take the Re J approach.
I mean, at the moment, I understand what the argument is, but I'm struggling to find what the good in it is, because I mean, one never likes to complicate the situation, saying that you apply this test in that situation and that test in this situation. But in some cases that's necessary. But here, if you're saying the court should be freed up in order to award costs on the basis of winners and losers, which bluntly is what you're saying, without need for reprehensible conduct, where's the benefit in that? And it cuts across the entire thinking about costs in cases involving children, and that where would you ever get a court awarding a winners and losers costs order where you wouldn't get reprehensible conduct? You might say, for example, there might be one where somebody's super rich and somebody's very poor, but you would get cost orders in those cases anyhow, would you not? Under one of the residual categories of case that didn't require reprehensible conduct. In the normal run of cases, I can't really envisage a situation where somebody would say, well, you haven't behaved particularly badly, but I'm going to award you, and you haven't got lots of money, I'm going to award you to pay the costs anyhow because you lost. Isn't that against the whole texture of the law as it's developed decades?
A number of points to make. Well, a lot of the points in response to what you've raised come under ground 5, where we say this particular case falls into an entirely different category. But on that specific point, no, this is the Re J analysis, because a fact-finding hearing, especially a bespoke one that deals with serious allegations and stands alone, the costs of that exercise are entirely referable to the issues that come before the court in it. If it can be prevented, it should be prevented. So in this case, for example, if there had been some limitation of the allegations or a robust case review at an early stage that had limited the nature of the mother's case, which ultimately failed on the tranche A points, that would have been in the interests of the parties and the children. In advancing it, significant costs have been incurred which are entirely referable, or in very large part very much referables, subject to the court's determination of percentage, to the tranche A points. How does it align with the general principles to then say, well, the party that was successful here, who incurred all these costs entirely needlessly, delay, everything else, has no ability to claw back those costs effectively. He must simply bear the burden, whatever the personal circumstances for him. More of a moralistic point. The straightforward point that Lord Justice Wilson made in the Court of Appeal in VJ is, where there's a bespoke fact-finding, not in the usual run of cases, but in unusual circumstances, you can take a clean sheet approach to remedy that.
I think one of the, I mean, I think you've made your submissions, so we'll move on. One of the fundamental problems is you don't have a split hearing, you have one rolled up hearing in which one parent is saying, absolutely, this must not happen, and will rely on certain matters, and they lose. And what they fundamentally opposed, say contact, an order for contact is made. What's the difference between that sort of situation and your separation out of a fact-finding hearing? They've lost, they've pursued allegations that weren't successful. They should have an order for cost made against them because they're the loser.
Where it's a rolled up
Yes,
fact-finding
what's the difference?
and welfare exercise. Well, I suspect, well, in fact, I would say the difference is, it's only allegations of a certain level that justify a bespoke fact-finding exercise. So by its very nature, because, well, for example, in this case, my lord, it would have been...
Yes, but then you're tipping over into the quality, reprehensible, unreasonable, rather than the fact. And what I'm just puzzled about is how you can distinguish it. Anyway, that's your submission.
Yes, well, you might be right that in an underlying analysis, my lord, there is a link between unreasonable conduct and advancing allegations of a certain scale. But where allegations of a certain scale that justify a bespoke hearing are raised and pursued, and then that bespoke hearing happens and is lost, in significant part, you have my submissions on the point. And it couldn't have ever come to a wrapped up hearing because the nature of these allegations could not have been dealt with at a wrapped up final hearing.
Okay, thank you.
Before I finish the point, there was a slightly more nuanced point, which is, it is not entirely clear, certainly in RT, and this is a criticism RES makes of RT, what is the binding ratio of RT in relation to costs on fact-finding hearings and costs moving forwards, and what is in fact simply dicta canvassed by the Supreme Court. RES, for example,
Yes.
was careful to say that some of the points raised in VT cannot have been as binding as they appear on the face of VT. And that's a point I've already taken you to in relation to the general circumstances. So if this court is of the view that the Supreme Court has forever removed REJ as a gateway in private proceedings, as many judges have said, it is important, we say, and this is a point that Recorder Dias drove at. I accept that judgment is not before you, it's not disputed. What element of the ratio is making that binding decision from the Supreme Court? Or is this court making that decision anew based on the discussion and analysis that has already in part been offered during the course of this hearing? And that goes to this overriding issue, which is both RES and RET were dealing with narrow questions within public law proceedings. And a lot of the wider commentary on costs did not directly link in to the ratio on the question that was specifically before the Supreme Court. Conduct then, my lords, although I suspect you already have my case.
Okay, we're coming to your main point now.
Indeed, my main point, my lords. I suspect you already have my case largely on it. And this is the paragraph 41, my lord, of my skeleton argument, which I'm going to use as a rough guide for myself. First of all, Recorder Samuels focused on the test of reprehensibility, and you'll have seen that in his judgment. Unless it would be helpful, I'm not going to take you to the relevant sentences. That is wrong. The test at the moment, based on all the authorities before you, is reprehensibility or unreasonable behaviour. Unreasonable behaviour, we say, is usually read as relating to litigation conduct. Reprehensibility relates to wider conduct in relation to children, for example. They have different thresholds. Reprehensibility clearly requires a higher standard of bad behaviour than simple unreasonable behaviour. In focusing on that, Recorder Samuels was in principle simply wrong, because much of what was argued in relation to costs was about procedural unreasonable behaviour, the warping effect that I've referred to in my skeleton argument of the tranche allegations.
Would you at some point when you're doing this take us to authority that helps on the distinction between reprehensibility and unreasonable behaviour?
My Lord, I, on this point, be open. We have searched for that authority. It is not plain that there is one that clearly demarcates the terms. What we have coming out of the 1990s authorities is the idea of unreasonable behaviour, and then through the mid-2000s, 2010s, reprehensibility is effectively brought in. And I may have missed an obvious case that clearly explains how they're to be demarcated, and I apologise if I have. And then in all the recent cases, they're simply used together in the way that we've been using them together and reading them together in the authorities. But they are clearly different. Unreasonable behaviour is not equal to reprehensibility.
Well, the first thing we have to focus on, don't we, is your point you made a moment ago as to what is the field of behaviour that one is talking about. And I'd always understood that when thinking about costs, you were thinking about the field of behaviour in the litigation, not behaviour in the field of parenting. Can you help us as to that?
I would agree with that, my lord. I say that the core test is and always has been unreasonable litigation conduct, unreasonable behaviour in the field of litigation. It is the inclusion of reprehensibility that muddies that water.
I'm not yet understanding.
As a headline point, my lord, that they simply, you may disagree with me on this, but they just can't be the same. Unreasonable behaviour and reprehensibility are two different terms of art with different meanings. Reprehensible behaviour is qualitatively worse than unreasonable behaviour. That must be right as a starting position. And that's why the early authorities will refer to unreasonable behaviour, which is a well-known cost term in all civil proceedings. CPR always looks to unreasonable behaviour when considering questions of costs, and it's a term that springs out of the statute. In fact, it's a term incorporated into section 26, for example. But it is the courts that over time have drawn in reprehensibility. As I say, I apologise, I've not found a genesis authority for
But as my lord says, that what's referred to is the conduct of a party, and the fact that you have different descriptions of it, whether it be reprehensible or unreasonable, it's the same conduct, or it's still referring to conduct. How can it be conduct outside the scope of the litigation?
Our general view is it can't and shouldn't be. And in fact, if you were to ask me what my concluding point on this was, I would say reprehensibility should fall away as an unhelpful term when it's weighed alongside unreasonable behaviour.
I think that's quite a bold submission, considering it's been approved by the Supreme Court and the House of by the Supreme Court.
But if we're looking for some archaeology here, then we find, for instance, in Lord Phillips's judgment in Re T, paragraph 15, going back through Sutton London Borough Council, through to Gojkovic, and back to Havering London Borough Council, paragraph 15 of Re T. And that's where for example, Mr. Justice Wilson in Sutton said that proposition is this is no costs order is not applied where, for example, the conduct of the party has been reprehensible or the party's status has been beyond the band of what is reasonable. So they both crop up there outside the band of reasonable stances. So that's probably where the trail would lead back to.
My lords, my lady, you may be against me. You may say they are the same, and the threshold that is.
It might be said that reprehensible had a bit more strength to it, but I mean, reprehensible means that it's fit to be reprimanded. You know, unreasonable is a state of affairs, but you might want to reprimand somebody for behaving unreasonably. It might be as broad as it's long.
No, I completely agree with that, my lord. But
the quality of the behaviour is such that it would be open to criticism. I think that's really what all of the synonyms are driving at. That it's not normal litigation conduct. It is doing something. It would be reprehensible if you deliberately make up a pack of lies about somebody and chase them down. But it could be unreasonable to pursue a particular avenue in circumstances where any reasonable person standing back would realise that the allegations were unfounded, and yet nevertheless you've convinced yourself that they're true. And that might be a distinction.
I would.
Here we're in the latter scenario, not the former.
I think my lady makes a good point, but I wouldn't necessarily put us straight into the latter. And I suppose that the question at the heart of it, and I'm not going to spend too much more of your time on this, the question at the heart of it is there a difference in threshold? They're always weighed together where reprehensible behaviour is mentioned. If unreasonable behaviour is lower, you may be against me on that, my lord, then I say the test should be unreasonable behaviour, and Recorder Samuels's focus on reprehensibility was wrong. If you are against me and I am wrong and they are the same, synonyms for exactly the same threshold that are interpreted in that way, then it is a point I need push no further. So far as the behaviour goes, I've listed some of it out at paragraph 41. You already, though, my lords, my lady, have identified that the main point, the simple existence of these allegations and the pursuit of them, is unreasonable in and of itself, particularly the manner in which they were pursued to an ultimate failure before the courts. And the resistance of the alienating behaviour allegation was equally wrong, again, pursued that resistance to its ultimate failure. But then I've also outlined some further factors which are important to factor in. One, and this is a point that Recorder Samuels identified in his fact-finding judgment, there was an issue about the mother identifying certain individuals in relation to one of the most serious allegations in this case. There was significant...
This is 41A.
Indeed, 41A.
Yes. You don't need to go through each of the... I thought you were going to add something.
No, I'm going to summarise the few main ones. I'm not going to read out the list, my lord.
Okay.
You have a lot of the other points, but the only other one that I would pull out is that at F, I identify, linking it back to paragraph 85 of the fact-finding judgment, that the mother in this case gave evidence which was simply untrue, which the court found to be false. And I would ask that you read paragraph 85, which should be on your page 126, I think.
Sorry, paragraph which again?
It's paragraph 85.
85.
Which is just the
Page
conclusion,
127.
very short point, that the mother was not a compelling witness, and then the critical lie, some of what she told the judge was, in his view, simply untrue. standing back, my lords, my lady, we say this is a case where, and I've already said this a few times in our questions, we're simply well over the threshold in relation to unreasonable conduct, given the nature of these proceedings, how they evolved, and the nature of the allegations, but then also the nature in which they were pursued, relentlessly, with dishonesty, and in a chaotic way. So the gateway is open on unreasonable conduct or reprehensibility if you find against me on that demarcation. Recorder Samuels was wrong not to make that finding. He should have found that there had been unreasonable conduct in this case which justified a cost order. Once he'd done so and he'd gone through the gateway, he would have then had a discretion as to what he did. But in simply determining that the muddy picture here didn't justify a cost order at all, he avoided that in principle decision in circumstances where he had specifically separated out the principle of costs from the quantum of costs. I will then, and I know I've taken a lot of your time, deal reasonably swiftly with my ground 5.
Well, you say should have made a cost order. What are you saying we should do? Or is that your concluding submission?
No, I have to say it now, my lord. I think we said it in the grounds, but I'll be corrected. We say you should impose your own order, exercise your ability to now set aside Recorder Samuel's order and say, in principle, there should be a cost order here for the fact-finding proceedings, and then send it back to Recorder Samuel's for the quantum stage.
So a full cost order for all the costs of the fact-finding hearing?
Yes, our starting point is for all the costs of the fact-finding hearing, accepting openly that you have a discretion to limit it to a percentage if you see fit.
And if we were to limit it to a percentage, would you make any submissions about the appropriate percentage?
Yes, my lord, if you have asked, we would say 80% because of the warping and overwhelming impact of the tranche A issues.
So paragraph 5, ground 5, is saying, is this a different test should apply when the court is determining whether to make an order for costs against a legally aided litigant?
Yes, so this is the novel ground.
Very novel.
My lord, very novel. Not been raised.
So what the 6th one, which you've abandoned, was ambitious, and this you describe as novel.
If pushed, my lord, I would describe 6 as incredibly ambitious. Hence it is fallen. Ground 5, yes, novel, but coming out of a number of legal points, which, so far as we can see, and again, it may be my bad legal research, my lord, haven't been wrestled with before. And I know you're not dealing
Has
with...
not been wrestled with before.
Yes, has not.
Yes, that might say something about it as a point. It might. It might.
It may very well, my lord.
Yes.
But we say our analysis on this is sound. We accept that it has been said in res that legally aided parties should not be treated differently to local authorities when they are receiving costs. There's a immediate point of distinction that I will draw. It is not dealt in res explicitly with the question of what should happen when a privately paying party seeks to recover costs from a legally funded party. And none of the authorities that we are aware of deal with this question of where it is openly said that there's going to be attempted cost recovery against the Lord Chancellor, and what should the approach be in family proceedings. Now, that may very well be because of the complex point we have skirted on regulatory interpretation that my learned friend argued, and whether it's possible at all. But we're not dealing with that today now. This is the principle that we placed before Recorder Samuels, condensed into a new exemption. We sought permission on a point that was a very rough cast version of this Recorder Samuels refused permission on that oral point and left it to my lords and my lady. The principle is this: where a privately funded party seeks to recover their costs from a legally aided party and openly accepts that any cost order at stage 2 from the party themselves is going to be de minimis, and where proceedings are already contested or acrimonious, then the court should adopt a different approach to costs. Now, the reason we say that is our close analysis of the principles that underpin res reti and all of the historic jurisdiction on cost neutrality in children proceedings. They're most aptly summarised in, as she then was, it's Justice Hale's, now of course Baroness Hale's judgment in R&R, and also spring out of the case we've already referred to, which is the London Borough of Sutton, that there's no real dispute about these authorities in this case, unless my learned friend says otherwise, my lords and my lady. The principles of this, in private law proceedings, and I've already made the point that private principles come into care proceedings and there are additional public law principles that surround them, but there's no authority that says all of the public law principles on costs flow the other way into private law proceedings. Indeed, the reasons I've set out, that would be nonsensical, because some of them would simply not apply to warring parents in private proceedings who might be litigating for very unreasonable reasons. The first headline principle is the concern that a cost order would diminish funds available for the children, or may in some way reduce resources available for the children. That cannot apply under this proposed third exemption, where the court knows that there will be no material, anything above de minimis cost order against the other party, there will be no loss to the family at all. In fact, if costs are then recovered from the Lord Chancellor, there will be an increase in the resources available to the family. So that pillar of cost neutrality just does not apply in the circumstances of this exemption. The second pillar, that people with a reasonable case to put forward should not be deterred. It's my words, my summary, my lords. Effectively, that a fear of a cost order should not stop people bringing legitimate disputes before the family court. That, again, cannot apply here, because there can be no fear of a cost order that is anything but de minimis. The court will not concern itself generally with de minimis concerns, but a risk of a de minimis £5 or £10 cost order is, we say, obviously on its face, no barrier at all to a party that wants to bring something before the court. And so that pillar cannot apply. And then finally, the general concern that it will increase acrimony between the parties, exacerbate tensions, although, as I note, whilst everyone refers to Baroness Hale's dicta at R&R, often missed is Lady Justice Stoughton's ratio, that principle is of not much significance in circumstances where there is little prospect of future cooperation, but nevertheless it is evolved into a core underpinning principle of modern cost law. And again, it cannot apply in relation to this proposed third exemption, because there will be no material payment from one party to the other, and so that concern falls away. And
those three factors don't apply. So yes, go on.
I'm so sorry, my lord, and just to say, separate to there being no material payment, we openly say this should only be in cases where tensions are very, very high. And so take the present case, it would be very difficult to see how a £10 payment could possibly exacerbate the temperature, given the allegations that have just been litigated at the fact-finding hearing, which you are aware of. And any suggestion that such a £10 payment would be a material increase in temperature or an acrimonious impact that would limit or affect the children is, we say, on balance of probability, is not a realistic contention in cases such as this one. Those, we say, are the three main pillars underpinning private law cost law and private proceedings as it stands today. My lords, if you consider there is a further pillar that should be wrestled with, I'm happy to engage with it, but on our reading of the law, that is correct. Of the public principles, I've dealt with a few of them in my skeleton argument. The one I've mentioned a number of times is this idea that all parties are motivated by concern for the child's welfare. We say that doesn't transpose into private proceedings, but wouldn't transpose anyway into a case like this, where acrimony is high, and in any event, not a reason in and of itself not to order costs. So we go much further than just saying there should be a separate gateway. We say the entire structure of costs law in relation to private law proceedings cannot apply in the circumstances of the proposed third exemption in this novel situation where there was an open attempt to go to the Lord Chancellor.
So what is the principle that the court should apply in determining whether to make an order for costs when the order is sought against a party who's legally aided?
So where the specific criteria, where this exemption applies, where all of its limbs are met, and we've hopefully carefully set it out, we'd say it then turns to a clean sheet.
So you're back to your clean sheet submission based on Re J.
But no,
So
sorry.
you're saying that in every case where the one party is legally aided, the court should adopt a clean sheet approach.
No.
No.
In every case where the other party is legally aided and there is an open binding to a de minimis cost award from that party, of course it's possible.
I understand, but how does that factor into the Re-T, Re-S test, reprehensible, unreasonable? Does it change the test?
We say it's entirely different. It's a different test. It's completely separate.
Right. So you don't have any regard to that at all. You make an order for costs on a clean sheet application.
So I'm so sorry. So you'd make an application for costs,
yes,
and then the court would assess it if you're through the gateway. So first of all, you have to get through a gateway to open up clean sheet. So cost neutrality is a wall, effectively. What's the way over the wall? We have said Re J, we've said reprehensible, unreasonable conduct. Here we're saying there's a third way over the wall. Once you're over the wall, you're just in clean sheet territory. However you get there, I suppose is a point I should.
Well, you set it out of paragraph 50 very concisely in your skeleton argument. But you're arguing for cost neutrality at this point in these very specific circumstances.
Indeed.
Looks to me like a ingenious way of trying to remedy what might very well be thought to be an unfair state of affairs, whereby one party gets legal aid and the other doesn't.
Well, indeed, and
that's really the thinking under this, isn't it?
Well, indeed, and in particular in this case, what my client would say, where one party's not just got legal aid but deployed it.
The difficulty with that is that for better or for worse, Parliament has spoken on this issue by means of a fairly complicated system of statute and regulation.
On the ability to recover against the Lord Chancellor, yes.
Yes, but I mean, in general, Parliament appears to be aware of the fact that one party gets legal aid and the other doesn't.
Indeed, my Lord.
That might not be on the basis of any deservings.
Look, there's no suggestion we want to contest that or fall into that sort of discussion, my Lord. Yes, you're right. Parliament has created legal aid, and some parties get it somebody's own. Parliament has also, we say, created a door to cost recovery against the Lord Chancellor. Here, the issue is, in what circumstances does the court make a cost order that might lead to what we say is then a statutory run-up to cost on the Lord Chancellor? And Parliament does not say that there is cost neutrality in children proceedings. It's the courts that have created cost neutrality in children proceedings. It is the courts that have created the exemptions to cost neutrality in children proceedings. And what we are, I should say, Re-T and Re-S say there are other exemptions and never give you a codified list. We say we have identified a novel exemption which stands entirely separate to the current cost system.
Thank you. Is there anything else?
I don't think so, my Lord. I'll very quickly turn my back. And as you're not determining the regulatory point, my Lord, whether it's possible or not, I suppose, is not something that's going to concern you. It's a matter for another day if the father, in this case, or some other father, pursues the point.
Thank you very much. Yes.
Very good.
Yes, Mr. Sandros.
My lady, my lords, without wishing to invite consideration of the section 26 cost protection point where it's not absolutely necessary, I am concerned to confirm whether the appellant's case to limit his costs ultimately sought directly from the mother remains de minimis. I'd understood, albeit it's not been confirmed, I think, in solicitor's correspondence or any document.
Well, I think it was confirmed openly in court today that it is the stated position.
My lord, I think outside of court I was told something slightly different, which is that if costs protection does not apply, the father would seek to enforce a substantive costs order against the mother, which may have particular relevance.
Right.
If my lords, my lady are
Thank
being
you.
invited
Let me just check. Yes. Yes.
My lord, it's not a matter that arises because you're not dealing with the regulatory point, but what I had agreed with my learned friend is if you had determined the regulatory point and determined that this was a door shut to us, the father would still pursue his grounds of appeal on the basis of unreasonable behaviour and or the VJ point. I'm sorry if I didn't make that clear at the outset, so we'd still seek a cost order. The de minimis point arises because we accept that under section 26 of LASPO, in this case, there must be a low award in any event, and we'd only seek £10. But if this court, and it's not going to do so now, was to disapply section 26, completely close down the entire foundation of our current cost analysis, I had told my friend we would still pursue the appeal. But that is not something you're going to have to wrestle with, my lord, my lady, today, because you've decided you're not going to deal with the regulatory point.
Yes.
My lords, forgive the discomfort. The way my learned friend puts it, that if this court were to disapply section 26, then...
Which we're not.
Which you're not.
Because we're not deciding it.
Quite. My concern is that the appellant father is deliberately leaving open the possibility of asking this court to make a costs order, making his application against the Lord Chancellor, court determining that that's not open to him, cost protection does not apply, and then seeking to enforce a substantive costs order against the mother in the terms that this court makes today because costs protection does not apply, having obtained that costs order from my lords, my lady, on the basis that he would not seek anything more than de minimis costs from the mother.
A costs order ought to be awarded or not is a separate matter. As I understand it, the father's position is that if you're entitled to cost protection, then he'll only seek a minimal order against you and see whether he can look elsewhere for the rest. I mean, if you're not entitled to cost protection, then that's a different matter, isn't it?
Quite.
I mean, are you asking for the father to give an assurance that if you are not entitled to cost protection, you're not going to face anything more than a minimal request for costs? Is that what this is?
My lords, my lady, no. I certainly wish to confirm the appellant father's case on this point because I will in due course come to respectfully submit that in exercising the discretion, if through the gateway, the court must consider all of the circumstances, and that in this case must include the fact that the costs order sought is against the carer of the children who's reliant on benefit income only and is in social housing. And that would form also part of the relevant considerations in deciding whether or not to make a substantive costs order at
Well, are you
stage
saying
one.
are you saying there's an overlap between the sort of considerations that go into the section 26 decision as to conduct, etc., as to what the assessment of costs should be or how much that person can afford and so on, and the question of whether any, in principle, a costs order should be made by reason of misconduct, reprehensible behaviour, whatever, and if so, whether it should be for the whole amount of the cost or only a percentage of it.
My lady, in short, yes.
Yes, I thought that's what you were saying.
The financial...
I see the force of that.
And I pray and aid not just what Lady Justice Hale says, forgive me, Baroness Hale, the other way in Re S, that a particularly wealthy, albeit reasonable litigant might be required to pay a cost ultimately if that would assist particularly the children, but that in the other direction, a primary carer for young children having to meet costs out of incredibly limited resources, which may well be an outcome of the order that the appellant father seeks, must be a relevant consideration.
Well, it's definitely relevant under section 26. It's the sort of thing that you come across in civil procedure when you're looking to see how much it is fair, just equitable for the losing party to pay in an ordinary winner-loser situation. So I'm totally familiar with that. But what you have is an overlap, because conduct or behaviour and the way in which the litigation is pursued is, in the widest sense, something which enables you to get through a gateway in the first place. And it's also one of the factors that go into the assessment of how much that particular person should be required to pay.
I take that point, my lady. It's at that stage that I say the financial resources also should form part. Forgive me if labouring point.
Why should it come in at stage one? What at the moment I'm struggling with? Conduct I can see comes in at both stages, or potentially comes in at both stages. Why should the fact that the mother is the primary carer for the children and her own limited resources affect the principle of whether it should be 100%, 50%, 75%, 2/3, whatever it may be? As a matter of principle, why should that affect?
I think, my lady, I go further and say it should feed into whether there should be a costs order, whether it's appropriate to make a costs order at all. Certainly if the resources available are
I have problems with that, because let's suppose not this case. Let's suppose you've got a parent who pursues what they know to be a totally false case against the other party in a private care proceeding. And it's shown that it's all a tissue of lies and they knew it all along. That's not this case. Why should the fact that that person is the primary carer for the children exonerate them from paying costs to the other side at all in that scenario?
My lady, it's a hypothetical I would wish to, I think, consider, and if I might address my lady on.
Well, I think in order to see how these things feed in, you need to test propositions to their limits, because we're dealing here with principle, matters of principle. And you say, as a matter of principle, when it comes to the question of whether the gateway is open, you factor in the question of whether or not you balance the behaviour, the reprehensible behaviour, against other considerations. And that's what I'm struggling with. I can see how it comes in at next stage.
My lady, forgive me, I think my confusion in relation to which gateways we're discussing.
Reprehensible or unreasonable conduct. All right.
Yes.
So you've got to, as I understand it, you are submitting that let us suppose that it is found that there has been reprehensible or unconscionable conduct, or whatever it may be, whatever the test is, whatever we decide the test is. So that's parked as a factor in whether or not to exercise the court's discretion, the gateway having been opened, as to make an award of costs at all. That factor, you say, is balanced against the fact that the person who is found to have engaged in such conduct is the primary carer for the children.
My lady, in short, because in such circumstances, it may be that the effect of the costs order would be simply to reduce the funds available ultimately to meet the needs for the children.
And that's before you factor in the legal aid aspect, which would suggest otherwise.
I'm sorry, Mr. Tendril, I think we're getting slightly ahead of ourselves.
Yes,
the orders for costs would often be made, in my recollection, not to be enforced without leave of the court. For example, when the court has not got the financial circumstances available to it to decide whether or not to enforce any particular part of it. if it had been thought relevant to the judge, and indeed to this court, to look at the financial circumstances of the parties, that doesn't seem to feature in the judge's order that he made, principle, i.e. should I make an order for costs, wasn't dealing with enforcement, wasn't dealing with assessment. Was it dealt with in evidence? Was evidence of financial circumstances put in by either side?
My lord, no, I think in
Right.
part because it was accepted in the document lodged by the appellant that the mother was, I think to borrow the word, impecunious.
Right.
Hence the open position of only seeking a de minimis nominal order. So I don't think there was a dispute.
No, but the
about
judge
it.
decided as a matter of principle on the factors he set out.
Yes.
Right.
I'm conscious, my lords, my lady, to have distracted matters really at a time, just in case
I think you
the
should.
bench
Yes.
been assisted to hear further from Mr. Davis
Yeah.
on this point.
I think.
But if I
Yeah. Deal with the.
need be return to it in due course, but
And can you deal with
otherwise-
ground 6 has been is not pursued, and just to tell you, we don't need to hear you on ground 5.
I'm grateful.
So if you can deal with the other grounds,
Certainly.
please.
Thank you, my lord. To perhaps restart
Yes.
by way of opening, at the heart of this case, of course, is a group of sibling children about whom very much remains to be considered and determined. Of course, there have been significant findings about the children's and the family's history made. There have also been significant consequences that have flown and continue to flow from that. My lords, my lady will have read of the commencement of public law outline following
Yes.
inquiries by the local authority, directed by the judge, the children being placed on child protection plans, assessment and intervention taking place, not just directed within the ongoing private law proceedings, but by those child protection processes, albeit not proceedings. My lords, my lady, have the report of the children's social worker following the judge's fact-finding judgment, and the local authority make clear and in no uncertain terms that if the mother undermines that process of assessment and intervention, then they will consider issuing care proceedings. Perhaps obvious point, the parents' cooperation and engagement with that process of assessment and intervention is with respect of vital importance for the subject children. And I say this is relevant and that these wider circumstances are relevant because they were undoubtedly in the judge's mind on the 8th of October when he made his decision on costs. At that hearing, in the judgment of that date that we have from the learned judge, he was considering a number of next steps in relation to the proceedings following the fact-finding. Responses really holistically to the fact-finding judgment and what should happen. There were a number of contested issues to deal with in relation to further reports, interim contact, whether the local authority in fact should share parental responsibility for the children. The father's position statement for that hearing in the bundle at 187 confirms, in fact, I think the third application by him for the children to be placed on interim care orders. And he was critical of the local authority's report and response of the findings and of the mother's statement of evidence responding to those findings. These are all the considerations from paragraphs 1 to 41 dealing with welfare and case management issues of Recorder Samuel King's Counsel's judgment of that day. The judge did not accept the father's criticisms of the mother's statement of evidence, of the local authority's report and analysis, that an interim care order was necessary, that the contact position put forward by the father was appropriate, or that the phrase put forward on behalf of the father that the position has crystallized such that removal from the mother is the only way to ensure the children have an ongoing relationship. That was the contention that was not accepted in the making of the decisions on that date. None of those decisions are subject to appeal. Together with those wider circumstances, the learned judge, with respect, clearly had the right principles in mind to apply. Indeed, at that stage, and he records in his judgment, the parties were agreed as to the principles to apply.
What I'm not understanding at the moment, I see that the wider circumstances are a context, but I'm not understanding why they bear upon the decision. Indeed, the judge didn't say that they did.
In relation to what the judge said, my lord, I think I have to accept it was perhaps infelicitous that he did not go further than the features of the case he identified at paragraph 61.
The judge might have said in a certain circumstance, well, it's much too sensitive, the current situation, for me to start making orders for costs. But that's not at all what he was saying or doing.
What he says, he lists the features of the case, my lord, that at paragraph 61, that if
None of those have got to do with the other two decisions that he was taking.
My lord, with respect, I say that there is relevance and there is sort of harking back to some of the comments earlier in his judgment in relation to the welfare and the case management issues. One, what he describes as the important distinction of his finding in relation to the child sexual abuse allegations not being that the mother was putting forward allegations which she believed to be false. That was something which also featured in the earlier discussion about welfare and case management issues, and was something that was a feature of the mother's statement, which was criticised on behalf of the appellant father, which criticisms were not accepted by Recorder Samuels and his counsel. My lord, the words of Recorder Samuel's case here I'd point to are those at paragraph 62, where it describes the mixed and nuanced picture of the case as he saw it. I say, as the court knows, that he was entitled to reach that conclusion. He was entitled to distinguish those cases where costs order have been made. I say, my lord, that even if the right conclusion were that the mother's conduct was through the gateway of unreasonable or reprehensible conduct, it was still open to the judge to exercise his discretion to make no order as to costs in respect of the fact finding, given all of the circumstances, including those features of the case that he refers to at paragraph 61. I say also, and with respect to the wider circumstance of the case, which he was clearly aware of, having considered and determined them in relation to the welfare and case management points. In applying the right principles, the learned judge, at paragraph 49, and indeed, I say, my lords, my lady, that not just at 49, but in all of his, those parts of the judgment where he sets out the law, he has set out the correct principles, referred to re-s, re-t, referred to the summaries as are available of the position on costs following those judgments of the Supreme Court in other helpful first instance cases. But a key part of those reasons mitigating against costs orders in children cases that he had in mind at 49 was that casting, stigmatizing winners and losers by the making of a costs order is likely to jeopardize the chances of cooperating in the future. And that's perhaps a particularly striking feature of this case in circumstances where, as I've said, so much remains open and in the balance. And it may have struck my lords and my lady that I think, save perhaps for a run of Mr. Justice Kean's cases, parental alienation numbers, I think 1 through 5 now, the costs orders in respect of fact-finding made, such as in Mrs. Justice Arbuthnot's CNS, are applications that come at the end of proceedings, rather than applications that come whilst there is so much still to be done within them. So I say, forgive me if labouring rather than clarifying, my lords, my lady, that it was open to Recorder Samuel's KC to find in the circumstances of this case no unreasonable conduct or reprehensible behaviour such that the gateway was not open to him. Alternatively, that even if the gateway was open, the right exercise of his discretion was to make no order as to costs in all the circumstances.
Which do you think he did? Or which is your submission that he did?
My lords, I would respectfully suggest that he did both. Found either that there's no, but I accept that has to be read in, and that it is, to say that's infelicitous that he doesn't go beyond identifying the features of the case and the comments he makes at paragraph 62 about it being a much more nuanced and mixed picture than the appellant father presents. But I would invite the court to read him as finding either on the first limb no unreasonable conduct or reprehensible behaviour, or that if there was, it was still the right exercise of his discretion not to make a costs order. I think that second step, that second decision of his, that it would be right not to make a costs order, is perhaps reinforced by what's at the top of the page, paragraph 61. I do not consider this to be a case where I should exercise my discretion to make a costs order in his favour. Inviting some sympathy to the judge, giving an extempore decision, I would perhaps only refer back to what I fairly confident will be well-known authority to this court about the virtue of brevity and of prompt decision-making for family in these cases. And in the circumstance of this case, where the father in particular was saying that this decision was of such importance to him that it would affect his position on whether to continue with the proceedings at all.
One of the points made by Mr. Davis is, and you're saying obviously this is exercised by first instance judge of his discretion, and we know the hurdle that has to be surmounted to overcome that it was an extemporary decision, so Piglovska and Polke and the others. One of the points made by Mr. Davis is there are some factors that don't feature in the judgment, and you've set out a list in paragraph 41. What's your submission in response to that?
My lord,
Are you coming to that?
I'm certainly going to come to it.
Don't worry,
to address.
then
I'm very grateful.
Come back to it.
Conscious of the time, I have every intention of addressing my lords, my lady, on paragraph 41
Then
and other aspects
I
of the
absolutely don't want-
fact-finding judgment.
I
that
don't
might
want to take you
concern
right
my
of your
lords.
course.
I'm very grateful. What I might be able to assist in the time between now and 1 is on the re-J exception.
Okay.
I've heard what my lords, my lady have said about that. I don't propose to labour the points, but if it assists just to identify perhaps a few additional points from the jurisprudence
Thank you.
and invite some
Yes.
thoughts about other policy reasons. So firstly, Baroness Hale's paragraph 26 has already been identified by this court.
Yes.
Lord Phillips' paragraph 44 in Re T also identified. I also, and I make no embarrassment that it's to borrow from my Lord Justice Jackson's judgment in M and F and H, the analysis of Lord Phillips' judgment from Re T.
Sorry, can you just tell me the paragraph?
It's paragraph 45 and 46
Thank
of
you.
M and F and H, referring back to paragraphs 22 as well as 44 of Lord Phillips' judgment in Re T.
Yes.
Also, my lords, my lady, paragraph 28 of Lord Phillips in Re T. It says the decision to have a split hearing cannot affect the principles to be applied by the court when dealing with costs, although it may have a practical impact on the court's decision.
Sorry, 1 minute. So, Re T 28.
Yes.
Yes.
I was a little surprised my learned friend referred to now Mr. Justice Diaz's decision. I accept what was said at paragraph 70 of that judgment, which is quoted in my learned friend's note.
Yes.
What he says at 71 of the judgment is that nevertheless, putting all the authorities together, I conclude that some form of unreasonable conduct by the party subject to adverse findings is generally necessary. I have been influenced by what was said in the Supreme Court in the case of Re T. So although paragraph 70 quoted by my learned friend makes it look like a first instance decision heading the other way, paragraph 71 seems to soften the position quite significantly.
It does. And
I did share that with my learned friend when the authorities bundle was being discussed. I know there's no difficulty taken with that being.
Well, it's not in our bundle, is it?
It's
I mean,
not.
I've read it online, but
right, thank you.
In respect of Baroness Hale's Re S, and so forgive me, a point made in my skeleton, where she refers to there being additional cases or circumstances in private law proceedings where a costs order might be warranted. She identifies as identified in the cases above.
Yes.
Re-J is not one of those cases. And I would respectfully suggest that if Baroness Hale had intended that the Re-J exception ought to be one, that she would have included it.
Your case is there is no reject exception.
Yes.
There might have been at the time of reject, but it hasn't survived, and we shouldn't revive it.
Precisely.
And that it would be extraordinary if this topic, the very close cousin, if not twin, of private law proceedings, had gone twice through the Supreme Court without them noting that there was a special case which they needn't concern themselves with.
Precisely so, my lord. In moving beyond jurisprudence into some policy points, I know which my lords, my lady have a number of in mind already. I respectfully suggest the approach would lead quite often to satellite litigation, perhaps in circumstances where cross allegations have been made and findings have been made in both directions.
Yes.
Where you simply invite further litigation about which findings cost more to determine.
What are you talking about here? You're talking about the re-J point still?
Yes, still, into now, I suppose.
So it would mean that
Policy
would be a
reasoning.
wider field for satellite litigation.
Yes. And perhaps related to that, I respectfully suggest it would add financial motivation to appeal court findings. It would build it into every case in which findings are made. If a costs order would automatically or near automatically follow the event at precisely the time when accepting court findings, it is what it would undoubtedly be in the children's interests as part of moving on to the next stage. I also would add, with respect, that as my lords have already identified, the absence of a distinction between fact-finding in split hearings and fact-finding in all-in-one hearings. If there was in fact such a distinction, you would have costs-motivated arguments at case management stage about whether to determine facts at a separate hearing or at an all-in-one. If you thought you were on a good case, you'd push for a separate fact-finding hearing because you know you'd have better cost protection.
Yes.
And that's not the right way
You
to make
create
those
illogical distinctions
Precisely.
Plus incentives.
and perverse incentives.
Yes. My lords, my lady,
Is
I'm
that a
conscious
convenient
of the-
moment?
I'm conscious of the time. I think that may
How
be.
much, can I just ask, without seeking to limit you at all, how much longer do you think you'll be? Just very roughly.
I think about 45 minutes.
Okay, thank you very much. So we'll start again at 2 o'clock.
All rise if they do.